I'm honored to be here today to introduce SB1146, which addresses the protection of victims from the egregious harassment of incarcerated individuals. These silent victims suffer emotional trauma and live in constant fear of something we all take for granted, the mail. These victims filed restraining orders or protective orders to the courts against the incarcerated expecting protection. This bill is inspired from a recent case where, as an individual was in custody on a case for stalking, despite a protective order, this individual sent multiple letters, cards, and notes to the victim while in custody. The DA's office was forced to just note the action. So despite the protective order, these forms of communication could not be intercepted, and the DA's office could not seek punishment for breaking the protective order. The victim was forced to constantly undergo the emotional trauma of seeing those communications each time they checked their mail. A protective order under existing law prohibits the contact of an individual via mail, verbal, nonverbal, or electronic means. The penalty for breaking a protective order is a $1,000 fine leading up to 1 year in county jail. Under current law, the penalty for breaking a protective order or restraining order has little to no effect on the incarcerated individual, as seen in this example. SB 1146 seeks to give victims that layer of protection from incarcerated individuals by allowing the prison authorities to inspect ongoing mail for the purpose of enforcing a restraining order or protective order against an inmate. Under current law, if an inmate sends a letter to an individual who has a restraining order against them, the victim can do the following. The victim can report the action and hope that the district attorney can file new charges against the inmate, which we are seeing is not happening. The victim can submit a written complaint to CDCR, administrative officials who can consider the situation and, if approved, may stop future mail. All this time, the victim is suffering from the emotional trauma of receiving mail from the inmate. To summarize, colleagues, SB 1146 simply gives the authority to enforce protective orders and restraining orders in both jails and prisons when the mail of each inmate is already searched before being sent out. Let's give a level of protection to these victims who have already suffered enough and expect us, the state, to help them enforce their protection. For all those reasons, I respectfully ask for an aye vote.
And Senator Stern, I understand that you will be taking amendments?
I will. As author amendments?
Okay.
Thank
Excellent.
you. Appreciate that. Appreciate the help of the committee.
You're welcome. And once we get to the point of motion, it would be a move as amended. All right. So witnesses in support. We already rolled call.
Sorry. Good morning, Madam Chair. Ryan Sherman with the Riverside Sheriff Association. Although this bill doesn't directly impact our members, we think it's good policy, and we're hoping that we can, at the county level, be included at some point along the way. Thank you.
Great. Any other witnesses in support? Any witnesses in opposition? All right. So, Senator Anderson, we have a motion. Senator Anderson, you may.
I don't think that you called on the senator. My mic was on. I'd like to move the bill.
All right, I'll accept that. Senator Anderson's motion as amended, or with the amendments.
Honored Senator Stephen Bradford.
Directly to the floor. Okay, we'll do a roll call.
Skinner?
Aye.
Skinner, aye. Anderson?
Aye.
Anderson, aye. Bradford?
Aye.
Bradford, aye. Jackson?
Aye.
Jackson, aye. Mitchell? Stone?
Aye.
Stone, aye. Wiener?
Thank you, Madam Chair, honorable members.